Third reading.
Call on Members' Order of the Day number 1.
Corpus Amendment Bill, Committee stage.
A point of order, Darian Fenton.
Mr Speaker, I seek leave for the Habeas Corpus Amendment Bill to be taken as one question.
Leave is sought for clauses 1 to 12 of a Habeas Corpus Amendment Bill be taken as one question. Is there any objection? There is no objection. I declare the House in committee for consideration of the Habeas Corpus Amendment Bill. Mr Chairman.
Speaker. The House and Committee for consideration of the Habeas Corpus Amendment Bill, and the question is that clauses 1 to 5 and clauses 7 to 12 stand part. Andrew Little.
Mr Chairman, thank you for the opportunity to speak at this stage of the Habeas Corpus Amendment Bill. This is a bill that the Labor Party will be supporting, and I just want to draw the House's attention to the fact that this is a very important right, or a set of rights, that we're dealing with in this bill. In fact, one of the most basic rights. It is a protection against arbitrary detention of citizens by the state. And so when we are looking at this, and this is an area of the law that forms part of the courts, the High Court's inherent jurisdiction, and it is unusual or difficult, in fact, to intervene on the court's exercise of its powers in this regard. So when we are legislating for this, then we need to treat very carefully. And the member who's sponsored this bill, Chris Oakenfold, I think has shown the appropriate sobriety and caution in championing this piece of legislation. He has followed to the letter. He has followed to the letter the recommendations of the Law Commission. And perhaps one day Mr Oakenfold might find himself sitting in that august body, but not today, as he shepherds through this bill. The point I would make in that regard is, my respect for Mr Oakenfold aside, is that this bill ought to have been one brought to this House by the Minister of Justice, but she hasn't done that. She has been busy closing courts. She has been busily destroying the effectiveness of the Auckland Family Court. But we are left with the assistance of Mr Oakenfold to consider this very important bill and the very important rights under it. What this bill does is takes away what is presently a mandatory requirement of the High Court when faced with an application for habeas corpus, to give it urgency, to give the court some discretion on managing it. And I have to say, sir, that this is a very sensible measure in that regard, because it means that other urgent and important applications that the court might have to consider can be managed in accordance with the priority of those applications, and that the court need not be totally hamstrung by these sorts of applications, important as they are. And I don't think they lose any sense of importance with the measures that are proposed in this bill. And the other important thing that the bill does is to allow the management of applications by video technology. Pretty a modern step in the 21st century. As I say, these are sensible changes. What is not sensible, sir, and I'll conclude on this point, what is not sensible is that this bill comes here being championed by a member using his rights as a member of this House. It is not brought here, an important piece of legislation like this is not brought here by the Minister, and it is important that actually in future we see a Minister of Justice doing what she is meant to do, not relying on members exercising their rights as members of this House to bring such important legislation. Notwithstanding that, Mr Chairman, Labor will be supporting this bill.
Should I take a call?
If you like.
If I may. Thank you, Mr Chairman.
Chris Oakenfold.
Thank you, Mr Chairman. I'd like to